Hello everyone, welcome to my auditing classes. So here we are going to start with company audit, and today's focus is on company auditor. So here we are going to start with the qualifications of a company auditor. That means who can become an auditor to a company. The first qualification or the basic qualification is that they should possess a certificate of practice under Chartered Accountants of Act 1949. So ಈ ಪರ್ಟಿಕ್ಯುಲರ್ ಆಕ್ಟಿನ ಪ್ರಕಾರ ಯಾರ ಹತ್ರ ಚಾರ್ಟರ್ಡ್ ಅಕೌಂಟೆಂಟ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ಸ್ ಇರ್ತದೆ ದೇ ಕ್ಯಾನ್ ಬಿಕಮ್ an auditor to a company. Any person who is having this certificate can become an auditor to a company. And the second aspect, partnership form. So we cannot imagine a single person auditing a big company. So for this purpose, a group of chartered accountants can come together and form a partnership firm. And this partnership firm can become an auditor to a company. And the last concept is ethical code of conduct, which is also the part of this act. So any person having these qualifications can become an auditor to a company. And the second thing is disqualifications. So here we are going to study the grounds under which a person will be disqualified from becoming an auditor to a company. The first one is body corporate. So in the previous slide, we have seen that a partnership firm can become an auditor to company, but not body corporate. So here, except partnership firm, any other forms of business cannot be an auditor to a company. ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫಾರ್ಮಿನ ಹೊರತಾಗಿ ಬೇರೆ ಯಾವುದೇ ರೀತಿಯಾದಂತಹ ಬಿಸ್ನೆಸ್ ಫಾರ್ಮಿನಲ್ಲಿ ಇರುವಂತಹ ಬಾಡಿ ಕಾರ್ಪೊರೇಟ್ಸ್ಗಳು ಬಿಸ್ನೆಸ್ಗಳು ಕಂಪನಿಗೆ ಆಡಿಟರ್ ಆಗಲಿಕ್ಕೆ ಬರುವುದಿಲ್ಲ ಎಕ್ಸೆಪ್ಟ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫಾರ್ಮ್. And the second one is employees or officials of a company. Any employee of their company or any officials of a company. For example, the director of that particular company cannot become an auditor to the same company, or CEO of the same company cannot become an auditor to the same company. So that is either employee or any officials cannot become an auditor to the same company. And the third one, indebtedness exceeding rupees 1,000 to the company. ಕಂಪನಿಗೆ 1,000 ರುಪೀಸ್ ಅಥವಾ ಅದಕ್ಕಿಂತ ಹೆಚ್ಚಿಗೆ ಪೇಮೆಂಟ್ ಮಾಡಬೇಕಾಗಿರುವಂತಹ ಸಿಚುವೇಶನ್ಸ್ ಅಲ್ಲಿ ಅವರು ಅದೇ ಕಂಪನಿಗೆ ಆಡಿಟರ್ ಆಗಿ ವರ್ಕ್ ಮಾಡಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. And the next one, relatives. So here, if any relatives are there in the board of directors, ಸೊ ಆಡಿಟರ್ನ ಯಾವುದೇ ರಿಲೇಟಿವ್ಸ್ಗಳು ಕಂಪನಿಯ ಬೋರ್ಡ್ ಆಫ್ ಡೈರೆಕ್ಟರ್ಸ್ಗಳ ಆಗಿದ್ರೆ ಇನ್ ಸಚ್ ಸಿಚುವೇಶನ್ ದೇ ಕ್ಯಾನ್ ನಾಟ್ ಬಿಕಮ್ ಅನ್ ಆಡಿಟರ್ ಟು ದ ಕಂಪನಿ ಬಿಕಾಸ್ ಆಡಿಟರ್ ಶುಡ್ ಬಿ ಅನ್ ಇಂಡಿಪೆಂಡೆಂಟ್ ಪರ್ಸನ್ ಫ್ರಮ್ ದ ಕಂಪನಿ. ಸೊ ಇಫ್ ಎನಿ ಪರ್ಸನ್ ಆರ್ relatives of the auditor, then in such situation they cannot be an auditor. Convicted by court. So if any auditor convicted by court for some frauds, in such situation they cannot be appointed as an auditor. Not more than 20 companies. A person, a single person, can act as an auditor to the company at the same time, not more than 20 companies. So he can act as an auditor to 20 companies at a time, but not more than 20 companies. The last requirement is that business relationship. So such auditor should not have any business relationship with the company. ಕಂಪನಿ ಒಟ್ಟಿಗೆ ಯಾವುದೇ ರೀತಿಯಾದಂತಹ ಬಿಸ್ನೆಸ್ ರಿಲೇಶನ್ಶಿಪ್ಸ್ ಇದೆ ಅಂತ ಹೇಳಿ ಆದ್ರೆ ಅಂತಹ ಸಿಚುವೇಶನ್ಸ್ ಅಲ್ಲಿ ಅಂತಹ ಪರ್ಸನ್ ಕಂಪನಿಗೆ ಆಡಿಟರ್ ಆಗಿ ವರ್ಕ್ ಮಾಡಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. You know that the reason is the auditor should be independent from the business. If he is having any relationship, a business relationship with the company, then he cannot be a, an auditor to the. And how to appoint the company auditor. So here there are several variations. If it is the first auditor after incorporation of the company, the rules are specified under section 139(1). So here, if it is for the first auditor, ನಮ್ಮ ಕಂಪನಿಗೆ ಮೊದಲ ಆಡಿಟರ್ನ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೇವೆ, ಆ ಕಂಪನಿಯನ್ನ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ ನಂತರ ಇದೇ ಮೊದಲು ಆಡಿಟರ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೇವೆ ಅಂತ ಹೇಳಿ ಆದ್ರೆ, so in such situation we should be appointed within 1 month of incorporation. So within 1 month of incorporation, an auditor should be appointed for the company. And the second one, for the subsequent auditor. He is not the first auditor, but he is a subsequent auditor. In such situation, in a first annual general meeting. So after the first auditor, the subsequent auditor is appointed by the company in the first general meeting, annual general meeting. Central government will appoint the auditor, but the thing is, which is in failure of subsequent auditors appointment. If the company failure to appoint subsequent auditors, in such situation, central government will appoint the auditor, but inform central government within 7 days. So after the annual general meeting, if they fails to appoint the auditor, the company has to inform the central government within 7 days. So in that situation, central government will appoint subsequent auditors. And the last one, special resolution under section 224A. So here, in the cases wherein which not less than 25% of the shares are held by the state. State means the government. In such situation, the auditor will be appointed under special resolutions. In the previous cases, it will be appointed in a general meeting by passing ordinary resolution, but here it should be under special resolution, where the company's shares, not less than 25% of the shares, is owned by the government. So you should remember these 4 points for the appointment of company auditor. And removal of the company auditor. So, of course, we have appointed a company auditor, but we want to remove him from the business before the expiry of his tenure. ಅವರ ಟರ್ಮ್ ಎಕ್ಸ್ಪೈರಿ ಆಗುವ ಮೊದಲು ಅವರನ್ನ ರಿಮೂವ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ, ಸೊ ಹಿಯರ್ ದೆರ್ ಆರ್ ಸಮ್ ಕಂಡೀಷನ್ಸ್. The first one, first auditor is removal, and the subsequent auditors removal. So first auditors can be removed by the shareholders in general body meetings. By passing an ordinary resolutions in the general body meeting, shareholders can remove first auditor. And the subsequent auditors, of course, the shareholders can remove, but here the shareholders can remove the auditor in general meeting, but they have to take the permissions from central government before such removal. Before removing the subsequent auditors, shareholders should get the permission from central government. But for the first auditors, they can remove the auditor in general meeting without getting any consent, without waiting for the approval from the central government. And process of removal. So how to remove the auditor? What is the procedure? So here we can study. So the first task they should do is they should give 14 days of notice by any member of the company. So here any member can give 14 days notice to company saying that they want to remove the auditor. And the second task is sending copy of the notice to the auditor. So they are decided to remove the auditor, and the member has to intimate the company regarding removal of such auditor. And the next task, they should send such notice even to the auditors also. So after receiving this kind of notice, auditor has to represent or has to communicate to the member or to the company. He can directly communicate with the company in personal, or they can represent themselves in the meeting. They can defend in the meeting also. They may mm, defend it to removed from the company. And by passing ordinary resolutions, they can be removed from the company's auditor force. So 14 days of notice from the member to the company, and the notice should be sent to the auditor. And the third task, auditors can defend himself or he can communicate with the company, of course, defending if any. And last one, ordinary resolution. Passing this, they can remove the auditor from the company. And this is the retirement of a company auditor. So here, first auditor will retire till the first annual general meeting. So it is the tenure of first auditor. ಫಸ್ಟ್ ಆಡಿಟರ್ಗೆ ಇರುವಂತ ಅವಕಾಶ ಎಲ್ಲಿಯವರೆಗೆ ಅಂತ ಹೇಳಿದ್ರೆ ಫಸ್ಟ್ ಆನ್ಯುವಲ್ ಜನರಲ್ ಮೀಟಿಂಗ್ ಅನ್ನು ಕಂಡಕ್ಟ್ ಮಾಡುವವರೆಗೆ ಮಾತ್ರ. ಆಫ್ಟರ್ ದಟ್, ಸೊ ಆಫ್ಟರ್ ದ ಫಸ್ಟ್ ಆನ್ಯುವಲ್ ಜನರಲ್ ಮೀಟಿಂಗ್, ಸೊ ದಿಸ್ ಫಸ್ಟ್ ಆಡಿಟರ್ ಕ್ಯಾನ್ ಬಿ ರೀಅಪಾಯಿಂಟೆಡ್. ಸೊ ಅವರನ್ನ ಪುನಃ ನೆಕ್ಸ್ಟ್ ಇಯರ್ಗೆ ಕೂಡ ರೀಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಅನ್ನು ಮಾಡಬಹುದು. ಬಟ್ the first annual general meeting is for the first auditor will get retired. And the subsequent auditor. So these subsequent auditors will get retirement on the next annual general meeting. So this year annual general meeting ಅನ್ನು ಕಂಡಕ್ಟ್ ಮಾಡಿದ್ದೇವೆ. ಈಗ ಆಡಿಟರ್ಸ್ ಅನ್ನು ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದೇವೆ ಅಂತ ಹೇಳಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಆನ್ಯುವಲ್ ಜನರಲ್ ಮೀಟಿಂಗ್ ವರೆಗೆ ಮಾತ್ರ ಅವರ ಟೆನ್ಯೂರ್ ಇರುವಂತದ್ದು. ಸೊ ಆ ನೆಕ್ಸ್ಟ್ ಆನ್ಯುವಲ್ ಜನರಲ್ ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ಎರಡು ಅವಕಾಶಗಳು ಇರ್ತವೆ. ಒಂದು, ಈಗ ಇರುವಂತಹ ಆಡಿಟರ್ ಅನ್ನ ಪುನಃ ರೀಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಬಹುದು, ಅಥವಾ ಹೊಸ ಆಡಿಟರ್ ಅನ್ನು ಅಪಾಯಿಂಟ್ ಮಾಡಿಕೊಳ್ಳುವಂತ ಚಾನ್ಸಸ್ ಕೂಡ ಇರ್ತದೆ. And the last task for this class is rights of a company auditor. So what are the rights? And in the next class, we are going to learn, of course, the duties. A right to refuse to commence the audit work. So he can start the audit work when he feels that all the required documents are supplied to the auditors. So if he feels some informations are lacking, he can deny starting his work. Or audit work ಅನ್ನು ಸ್ಟಾರ್ಟ್ ಮಾಡುವಂಥದ್ದು ಡಿನೇ ಮಾಡುವಂತ ಎಲ್ಲ ರೈಟ್ಸ್ ಆಡಿಟರ್ಗೆ ಇರ್ತದೆ. Right to access the books of accounts and records. So he can ask for any books for verifications. And it will be the duty of the company to provide whatever the records or the documents asked by the auditor. Right to examine the cost records. So here, auditor is appointed to find out or rectify the financial records. So that doesn't mean he cannot or he should not ask the cost records. Or financial aspects, ಫಿನಾನ್ಷಿಯಲ್ ಅಕೌಂಟಿಂಗ್ ಅನ್ನ ಮಾತ್ರ ವೆರಿಫೈ ಮಾಡುವಂಥದ್ದು, ಕಾಸ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಗಳನ್ನ ವೆರಿಫೈ ಮಾಡ್ಲಿಕ್ಕೆ ಇಲ್ಲ ಅಂತ ಹೇಳಲಿಕ್ಕೆ ಚಾನ್ಸಸ್ ಇಲ್ಲ. So he is having the rights to verify even the cost records and financial records as well. Right to get explanation from the employees for any aspect. So he can question any employees or the members or the directors of the company. Right to correct any wrong statements specified in the books of accounts. A right to comment on the inadequacy of the accounting. So he can comment in his report inadequacy of the accounting for the improper accounting, that he can mention these aspects in his report. Right to visit the branches. So here auditor is not specified to only the head office. He can visit any branch offices as well, but he can visit to any branches except the foreign branches. or a foreign branches ಗಳನ್ನ ವಿಸಿಟ್ ಮಾಡಲಿಕ್ಕೆ ಪರ್ಮಿಷನ್ಸ್ ಇರೋದಿಲ್ಲ. Within the country he can visit any branch office. Right to receive the notice of general meeting and attend the same. So all the general meeting, for all the general meeting, company has to send a notice, uh, even to the auditor as well. ನಮ್ಮ ಡೈರೆಕ್ಟರ್ಸ್ ಮೆಂಬರ್ಸ್ಗೆ ಹೇಗೆ ನೋಟಿಸ್ಗಳನ್ನ ಕಳಿಸ್ತೇವೆ, ಇನ್ ಸೇಮ್ ಫಾರ್ಮ್ಯಾಟ್ ಆಡಿಟರ್ಗೆ ಕೂಡ ಆ ನೋಟಿಸ್ ಅನ್ನ ಕಳಿಸಲೇಬೇಕಾಗ್ತದೆ. ರೈಟ್ ಟು ಸ್ಪೀಕ್ ಅಟ್ ದ ಜನರಲ್ ಮೀಟಿಂಗ್, ಅವ್ರ ಜನರಲ್ ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ಮಾತಾಡುವಂತ ರೈಟ್ಸ್ ಕೂಡ ಇರ್ತದೆ. ಸೊ ದ ಕಂಪನಿ ಕೆನಾಟ್ ಡಿನೈ ದ ರೈಟ್ ಆಫ್ ಸ್ಪೀಕಿಂಗ್ ಇನ್ ಜನರಲ್ ಮೀಟಿಂಗ್. Right to make representation or speak at the general meeting when he is asked to vacate his office. He can defend his removal from the auditor post. Right to receive legal and technical advices from the expert in the company. Right to sign the audit report. Of course, it is the duty as well. Audit report is prepared by the auditor at the end of audit work, and he has to sign this. Right to submit his report to the members of the company. So this is the end result of audit work. He has to submit his report to the members of the company. Right to be indemnified. So for any expenses during the course of audit work should be reimbursed by the company. Right to claim remuneration. So whatever the amount fixed, so for such amount he can claim. That it is his right to claim for such remuneration. So hope you understood. In today's class, so we have learned various aspects regarding company auditor. So we have started from the qualifications. So we have seen how to appoint the a company auditor, what are the disqualifications of the company auditor, how to remove the company auditor, and the rights of company auditor. So hope you understood. Thank you for watching. Take care and happy learning. And we'll meet in the next video that is regarding duties of company auditor. Thank you.